Section 6 Disinheritance Article 915. A compulsory heir may, in consequence of disinheritance, be deprived of his legitime, for causes expressly stated by law. Article 916. Disinheritance can be effected only through a will wherein the legal cause therefor shall be specified. Article 917. The burden of proving the truth of the cause for disinheritance shall rest upon the other heirs of the testator, if the disinherited heir should deny it. Article 918. Disinheritance without a specification of the cause, or for a cause the truth of which, if contradicted, is not proved, or which is not one of those set forth in this code, shall annul the institution of heirs insofar as it may prejudice the person disinherited, but the devises and legacies and other testamentary dispositions shall be valid to such extent as will not impair the legitime. Article 919. The following shall be sufficient causes for the disinheritance of children and descendants, legitimate as well as illegitimate. 1. When a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 2. When a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. 3. When a child or descendant has been convicted of adultery or concubinage with the spouse of the testator. 4. When a child or descendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 5. A refusal without justifiable cause to support the parent or ascendant who disinherits such child or descendant. 6. Maltreatment of the testator by word or deed, by the child or descendant. 7. When a child or descendant leads a dishonorable or disgraceful life. 8. Conviction of a crime which carries with it the penalty of civil interdiction. Article 920. The following shall be sufficient causes for the disinheritance of parents or ascendants, whether legitimate or illegitimate. 1. When the parents have abandoned their children or induced their daughters to live a corrupt or immoral life, or attempted against their virtue. 2. When the parent or ascendant has been convicted of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 3. When the parent or ascendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found to be false. 4. When the parent or ascendant has been convicted of adultery or concubinage with the spouse of the testator. 5. When the parent or ascendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 6. The loss of parental authority for causes specified in this code. 7. The refusal to support the children or descendants without justifiable cause. 8. An attempt by one of the parents against the life of the other, unless there has been a reconciliation between them. Article 921. The following shall be sufficient causes for disinheriting a spouse. 1. When the spouse has been convicted of an attempt against the life of the testator, his or her descendants, or ascendants. 2. When the spouse has accused the testator of a crime for which the law prescribes imprisonment of 6 years or more, and the accusation has been found to be false. 3. when the spouse by fraud, violence, intimidation, or undue influence cause the testator to make a will or to change one already made. 4. When the spouse has given cause for legal separation. 5. When the spouse has given grounds for the loss of parental authority. 6. Unjustifiable refusal to support the children or the other spouse. Article 922. A subsequent reconciliation between the offender and the offended person deprives the latter of the right to disinherit, and renders ineffectual any disinheritance that may have been made. Article 923. The children and descendants of the person disinherited shall take his or her place and shall preserve the rights of compulsory heirs with respect to the legitime, but the disinherited parent shall not have the usufruct or administration of the property which constitutes the legitime.